What's up, everyone out there in YouTube world, social media world, the world? Welcome to another episode of Musings with MGL. I'm your host, as always, MGL. Today's episode, just going to get right into it. Big win for Second Amendment advocates coming out of the Supreme Court. Everybody's kind of talking about it. It's all a buzz over the internet. But there was a case that was sent up to the Supreme Court recently called Caniglia versus Strom. Caniglia versus Strom. This case had to deal with law enforcement's ability to go into somebody's house without a warrant and confiscate their firearms. Okay. Essentially, there are a few exceptions to the warrant requirement. As everyone knows, or you should know, in the Fourth Amendment of the Constitution of the United States, law enforcement cannot enter your home without a warrant. They cannot enter your home, certainly to seize any of your property, without a warrant. There are a few exceptions to that, the main one being what they call exigent circumstances, which means if somebody is, and it's actually an example that Scalia, I think, maybe used in his opinion, if a law enforcement is looking through a window and sees somebody inside about ready to murder somebody else inside, they can go in the home and prevent that murder without needing a warrant. It's called exigent circumstances. Sometimes you see this applied to drug cases, where if they knock on a door and they're looking through the window and they see somebody flushing the drugs down the toilet and they're losing evidence, then they say sometimes you can go in there and get the person on exigent circumstances. Sometimes you can do it in hot pursuit of a felon. In other words, if somebody, let's say, commits a felony and you're chasing them in your car, in a fleeing to elude situation, lights and sirens, they pull into their driveway, they get out, and they run into their home. Sometimes, again, because of exigent circumstances, hot pursuit, sometimes you can follow that person in the home to effectuate your arrest. So there are a few exceptions to that rule, but they're very, very few. This case turned on an exception, which is basically called the public safety exception, meaning there are certain things that the government can do that are in public good that they normally couldn't do if it wasn't in the public good. So I'll just get right into this, and it will explain a little bit better when you read through the article. So it's all over all the articles. You can just Google it, but I'm reading from AmericanMilitaryNews.com because I like to get my stuff from non-left-wing sources, but they're a pretty good rundown of the ruling, actually. So I'm just going to read it here. That's why I got the glasses on. The Supreme Court ruled Monday that warrantless gun confiscation from Americans' homes is unconstitutional, voting unanimously on the side of a Rhode Island man whose firearms were taken by law enforcement without a warrant after his wife expressed concerns that he might hurt himself. According to Caniglia versus Strom, a lower court had previously determined that police confiscating the guns without a warrant fell under the Fourth Amendment's community caretaking exception. But a 9-0 vote from the nation's top court struck down that ruling. And that's important when you think about it. Again, it's a 9-0 vote. So even the left-wing justices struck this down. And that's because generally even the left-wing justices don't like cops going into people's houses without warrants. The left wing is generally anti-cop, and so anything that gives cops more powers, they're generally against. This case was a little different and weird because it involves firearms. So here you have two competing left-wing ideologies. We don't like cops, but we also don't like guns crashing into each other. And so you even had the Biden administration supporting this ruling, not the 9-0 ruling, but the underlying ruling, which said the cops can go take your stuff. They actually asked the Supreme Court to uphold that ruling and allow cops to go into somebody's house under this Community Caretaking Act and take firearms. And even the three liberal justices on the court and the fourth, sometimes liberal Justice Roberts on the court said no, 9-0, you can't do that. So Justice Clarence Thomas, those of us on the right's one of our big heroes, wrote the unanimous opinion for the Supreme Court, stating that law enforcement can execute many civic tasks in modern society, but there is not an open-ended license to perform them anywhere. The very core of the Fourth Amendment, Thomas wrote, is the right of a man to retreat into his own home and there be free from unreasonable search and seizure. Some exceptions to the Fourth Amendment do exist, including exigent circumstances. For instance, if an officer sees an individual about to shoot another person through the window at home, that officer has a right to enter the home, etc., etc. I talked about that already. Another exception, the one on which this case was based, is called, quote, community caretaking. The Supreme Court previously determined that police can bypass the warrant requirement to perform community caretaking functions totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute, noting a situation when police took a gun from the trunk of an impounded vehicle without a warrant. In reaching this conclusion, the court noted that the officers who patrol the public highways are often called to discharge non-criminal community caretaking functions, such as responding to disabled vehicles or investigating accidents. But searches of vehicles and homes are constitutionally different, as the Caddy opinion repeatedly stressed, Thomas wrote in the court's opinion. So what they were saying there is they were trying to extend an exception that applies to cars to your home. So I see this a lot as a criminal defense attorney, and you'll see it in other places too. And when somebody's arrested for a crime and the cops basically impound their vehicle, they have the right to search that vehicle before it gets impounded for various reasons. One of them being the community caretaking. You want to make sure there's nothing in there that's dangerous, that somebody could break into the car while it's at the impound lot or whatever and seize it. They also like to do what's called an inventory search, so that way when the people get out of jail, they can't come back and say, hey, I had a $1 million Picasso in the trunk and now it's gone. So they'll do what's called an inventory search of the vehicle, give a list of the items that it owns. That way it can basically cover their butts in a lawsuit. So there's a couple of exceptions that you don't need a warrant to search a car, one of them being caretaking and one of them being like an inventory search. So they were trying to take that caretaking thing that was applied to vehicles and extend it into your home, and the court said, we recognize that vehicles, because they're out in the public, et cetera, cops always do safety things with vehicles. If you're driving down the road with a flat tire, they'll pull you over to check on your flat tire. If you're disabled on the side of the road, they'll do that. If they have to tow a vehicle, they want to make sure it's safely stored. So there are some different reasons for doing those type of things with cars than there are with homes, and the Supreme Court said no. So in this case, Mr. Caniglia and his wife were arguing when he put an unloaded gun on their table and said, shoot me now and get it over with. Following the argument, Caniglia's wife called the non-emergency police line, leading to a visit from law enforcement. The police convinced Mr. Caniglia to go to the hospital for psychological evaluation, despite disagreeing that his behavior was abnormal and agitated. While he was on his way to the hospital, his wife told the police that he had 2 pistols in the home, at which point the officers searched the home without a warrant. However, Miss Caniglia couldn't provide legal consent because the police lied, telling her that Mr. Caniglia had consented to the seizure of his firearms. They located handguns and took them, prompting the lawsuit. Justice Samuel Alito wrote a concurrent opinion for the ruling in which he addressed existed red flag laws. Now, this is where the next step's going to be in this, and I'll do another video on red flag laws probably later this week. But the case, Alito quotes, the case also implicates another body of law that petitioner glossed over, the so-called, quote, red flag laws that some states are now enacting. These laws enable police to seize guns pursuant to a court order to prevent their use for suicide or the infliction of harm on innocent persons. They typically specify the standard that must be met and the procedures that must be followed before firearms may be seized. Provisions of red flag laws may be challenged under the Fourth Amendment, and those cases may come before our decision. Before us, our decision today does not address those issues. So they didn't address the issue of red flag laws coming in. Again, I'll do another video on those, but in short order, that allows them to go in and take your firearms without permission, or under the red flag laws without being charged with a crime or Baker Acted or anything along those lines. So it's a whole different issue. But I'll do another video on that soon. And I'm trying to remember. I've done so many videos now. I may have already done a video on red flag law, so I'll double check that first. But if not, you can search through my videos and see if I've done one. In March, the Biden administration urged the Supreme Court to uphold the lower court's ruling, arguing the actions taken by law enforcement to confiscate the petitioner's firearms without a warrant were reasonable. The touchstone of the Fourth Amendment is reasonableness, the DOJ's brief stated. For criminal investigations, this court has generally incorporated the warrant clause into the Fourth Amendment's overarching reasonableness requirement, but has not generally done so for searches and seizures objectively premised on justifications other than the investigation of wrongdoing. So what the Biden administration was trying to say is, because this wasn't a criminal investigation, you don't apply the same things that you would in a criminal situation for a warrant, because they weren't looking for evidence to charge him with a crime. They were only looking for his firearms. So the Biden administration was trying to say, therefore, you only have to look at it as reasonableness and not the high standard that you usually do for a warrant. And the Supreme Court, all 9 of them, including the 3 liberal justices and the usually very liberal Justice Roberts, all told him to pound sand and take a hike. So the Biden administration wanted them to continue to allow cops to take firearms based under the safety exception, and the 9-0 decision by the Supreme Court said no. So this may bode well for upcoming decisions in the Supreme Court. Remember, I just did a video last week that the Supreme Court is getting ready to take up a big Second Amendment case. A lot of people are excited about it. I think a lot of people on the left, the anti-gun people, are worried about it because they think with the current makeup of the court that may be good for them. So the fact that they agreed to take up that case and that they ruled 9-0 in this particular case might bode well for Second Amendment going forward with the Supreme Court. But again, you never know. I don't trust some of the wishy-washy people in the middle, even with the quote 6-3 thing. You shouldn't read into this too much and think that means we're headed for a bunch of pro Second Amendment rulings. But this one on its own merit is a good ruling. That was insane that they were able to get that all the way up to the Supreme Court on lower rulings that said they had a right to do that. And then all 9 of the justices said, piss off, basically. No, you don't have a right to do so. So that's the video for today. A really good ruling out of the Supreme Court on the Second Amendment. So keep an eye on that. If you like what I have to say, please hit the subscribe button, click the notifications, like, share, comment, tell everybody about the channel, all that kind of stuff. And as always, stay safe, stay healthy, and carry on.